Jury not present.
The court said, "Please be seated. Mr. Kamraju, is he?"
Ms. Shrofa said, "Good afternoon, Your Honor. He isn't here, but—"
The court said, "Oh, has there been a decision with respect to whether or not Mr. Guo will be taking the stand?"
Mr. Skirik said, "There has not yet, Your Honor."
The court said, "Mr. Guo, do you understand that you have the right to take the stand and testify in your own defense?"
Ms. Shrofa said, "Your Honor, may we just have a moment?"
The court said yes.
Ms. Shrofa said, "Thank you."
Ms. Shroff conferring with the defendant.
Ms. Shrofa said, "Thank you, Your Honor."
The court said, "So Mr. Guo, you understand that you have the right to take the stand to testify in your own defense?" The defendant, yes. The court said, "And you're going to discuss that with your attorneys thoroughly, and I am going to return to this question about whether or not you're going to take the stand. Do you understand?" The defendant, "Yes, Your Honor." The court said, "All righty. Let us have the jurors brought in, please."
Jury present.
The court said, "Please be seated, and the defense may call its first witness."
Mr. Skirik said, "Thank you, Your Honor." The defense calls Raymond Dragon.
Witness sworn.
The court said, "Would you please state your name and spell it?"
The witness said, "Yes. My name is Raymond Joseph Dragon. That's Raymond Joseph Dragon.
The court said, "You may inquire."
Mr. Skirik said, "Thank you, Your Honor."
Raymond Joseph Dragon, called as a witness by the defendant, having been duly sworn, testified as follows. Direct examination. By Mr. Skirik.
Good afternoon, Mr. Dragon. Where are you currently employed? I am employed at Anshin, Block and Anshin, LLP. Okay. And what is Anshin, Block and Anshin? Anshin, Block and Anshin is an accounting and consulting firm based in New York City. Okay. Thank you. Mr. Dragon, where did you go to school? I went to undergraduate college at Lehigh University, where I majored in international relations and graduated with high honors. I have a Master of Business Administration degree, commonly referred to as an MBA, from the Kellogg School of Management of Northwestern University. And I have a Master's of Science degree in economics from the University of London. Okay. Now just returning to your current employment at Anshin, Block. How long have you been with that firm? I've been with Anshin for 8 years. Okay. And what is your role at Anshin? At Anshin, I'm the Director of Business and Intellectual Property Valuation. And how large is that group at Anshin? The group is called our Forensic Litigation and Valuation Services Group. And it's approximately 20 people. And did I understand you correctly that you're the head of this group? I am the head of the Valuation Services. The overall head of the group is Anthony Bracco. Okay. Now what do you do in the Valuation Services Group? What services do you provide? I provide valuation of privately held companies, interests in companies, and intellectual property. Okay. And prior to your time at Anshin, Block, do you have other experience in valuation services? Yes. I've used valuation services in a variety of roles. I worked for an international bank in the mergers and acquisitions area. I worked for an international trading company, looking at their venture investments. All of these jobs require the use of valuation skills. And for approximately how many years before you joined Anshin did you work in those other roles that you just described for us? In addition to valuation consulting, my overall valuation banking and investment experience is over 25 years. Okay. Now do you have any certifications in the field of business valuation? I do. I'm an accredited senior appraiser with the American Society of Appraisers in the area of business valuation. And what does it mean to be a certified appraiser? Membership in the American Society of Appraisers requires that you complete a course of study specifically devoted to valuing privately held businesses. That you have at least 5 years of experience valuing privately held companies. And that you submitted 2 peer-reviewed reports of business valuations that the Society reviewed and found acceptable. Okay. Now are you a member of any other trade associations or professional groups related to business valuation? Yes. I'm also a certified patent valuation analyst. And I'm a member of the local New York City American Society of Appraisers chapter. Okay. Thank you for that description of your experience. Now what have you been asked to do as part of this case? I've been asked to determine the value of the equity of GTV Media Company. Okay. Now have you been compensated for your work on this matter? I have. Okay. And how? I bill at an hourly rate for my time. And what is that hourly rate? My hourly rate is $695 an hour. Okay. And approximately, to date, what have your total fees been? Approximately $68,200. Okay. Now have you also been reimbursed for some of your expenses? Yes. And can you just describe those briefly for the jury? Sure. I have driven into Manhattan to testify to this court area. I have parked my car. And I have also had bridge tolls. So those all together, the toll is, I believe, for New York bridges, 17.63. The parking is about 30, and the other component is, the mileage is about 67 cents a mile. Okay. And is it the case that the defense team here has agreed to cover your travel costs that you just described? Yes, it is. Okay. Now does your compensation here today depend in any way on the outcome of this case? No, it doesn't. Does your compensation depend on whether you testify a certain way? No, it doesn't. And before you were engaged on this matter, had you and I ever worked together before? No. This is the first time that I've ever been on a case where you've been present. Okay. And how about any other member of the defense team? Have you ever worked with any member of the defense team before this engagement? No. Okay. And then how about Mr. Gua? Have you ever done any work for Mr. Gua before? No. Okay. Now I'd just like to talk a bit about what materials you reviewed in connection with your engagement. What materials did you review prior to your testimony today? I reviewed the April 20, 2020, private placement memorandum. I reviewed valuation report from a consultant. I reviewed company forecasts. I reviewed a consultant's forecast.
Mr. Ferguson said, Your Honor, objection. It's not in evidence.
The court said, sustained.
Okay. Apart from the forecasts that you were just describing, can you please describe what other materials you may have reviewed?
Mr. Ferguson said, same objection.
The court said, sustained to the extent they're not in evidence.
Mr. Skirek said, Your Honor, may we have a brief sidebar on this, please?
The court said, okay.
Continued on next page. At the sidebar.
Mr. Skirek said, Your Honor. The way we understand the court's rulings is that the witness is permitted to review any number of materials. Even those materials that are not in evidence, and at this point I'm simply asking him what he reviewed. He's not relating any hearsay from those documents, which of course we understand Your Honor has ruled on. He's simply describing to the jury what materials he's reviewed.
Mr. Ferguson said, those materials relate to portions of his proposed opinions that the court has excluded. So I don't know why they would be relevant, particularly with reference to the consulting report. That's the A&M report that Your Honor said cannot be part of his testimony. I think the comparator companies is another example of what cannot be part of his testimony. So I don't see how this is relevant at all, in addition to not being evidence.
The court said, so are you referring to general materials not specific to this case?
Mr. Skirek said, no, Your Honor. We're referring to materials that are specific to this case. But Mr. Ferguson objected. Your Honor sustained the objection when he listed materials that I take it the government takes the position are, out of bounds based on the court's rulings. I then asked him, aside from those materials, have you reviewed anything else, trying to?
The court said, but I don't know what he knows. How do I know what's been excluded? Does he know?
Mr. Skirek said, aside from the materials that the government objected to him testifying about. I asked what else has he reviewed, so.
The court said, yes, but I don't know that he can read the government's mind. So I just don't want him to start talking about something that's prohibited.
Mr. Skirek said, understood. He is aware that I am representing to the court there are other materials that he's reviewed that have nothing to do with the materials the government has objected to. That's all I'm trying to get out.
The court said. Like what?
Mr. Skirik said, he's reviewed a couple of stipulations in the case that are relevant to his testimony. And he's reviewed, there are other materials. It's escaping my mind at this point. But there are other materials having nothing to do with materials that the court has excluded.
Mr. Ferguson said, if he wants to just lead and say, did you also review stipulations, that's fine. Just to make this faster.
Ms. Shrofa said, or he can object and she can decide.
The court said, so there was a suggestion. Go ahead and lead.
Mr. Skirik said, okay. I'll take the court up on it.
In open court. By Mr. Skirik.
Now, Mr. Dragon. Did you also review other materials that were provided by the defense to you in connection with your preparation for testimony today? I did. Okay. And did you review certain stipulations that were entered into by the parties in this case? I did. Okay. And were there other materials in addition to that as well? There were. Okay. Now did you perform a valuation analysis of GTV? I did. Okay. Can you just briefly explain the methodology that you used to the jury? Yes. In valuation, I use what is called a market approach. Mr. Dragon, we're focused on the particular approaches that have been the subject of recent discussions.
Mr. Ferguson said, and Your Honor, we would just move to strike reference to the market approach.
The court said, yes, that is stricken.
Okay. The methodology I used is called the backsolve method. Can you just explain to the jury briefly what that is? Yes. The backsolve method is that, used to determine the value of a company by looking at the value of a large transaction in the company's shares. Mr. Skirik said, okay. Your Honor, the defense offers Mr. Dragon as an expert in business valuation.
The court said, any objection?
Mr. Ferguson said, no objection.
The court said, all right. So he is qualified as an expert in business valuation.
Mr. Skirik said, thank you, Your Honor.
By Mr. Skirik.
Mr. Dragon, what is a valuation analysis? A valuation analysis is determining the value of a company or its stock or a portion of its stock for various purposes. In cases where the company is not publicly traded. With a publicly traded company like, say, Ford Motor Company. I could go to the New York Stock Exchange and see what the price of a Ford share is today. And then I could multiply that by the number of Ford shares outstanding and come to the value of the stock of Ford Motor Company. A valuation expert is called in when the company is not publicly traded. Okay. Thank you for that. And can you just explain to us why a valuation analysis may be performed? Sure. The valuation analyses are performed for a variety of reasons. I mean, one of them is if, say I have 3 partners in a business and one of them is getting old and wants to retire. And the other 2 partners want to buy him out. So the question is, what's a fair price for his portion of the company? That would be one example. A second example would be for estate and gift tax purposes. The IRS requires that if I gift, say, 25% of a company I own to my children, that I have that valued so that the IRS knows the value that was given to the children for estate and gift tax purposes. Another reason valuations are performed is for financial reporting. If a company is a company getting an audit, according to generally accepted accounting principles. Let's say this company has an investment in another company that's private. The generally accepted accounting principles, which are often referred to as GAAP. You may have heard that term, are that this investment has to be valued at its fair value. So in order for the financial statements to be accurate. So in that case, the investment that one company has in another company would be valued. So that's another example. Another example of valuation being used is in divorce cases under marital law. You have to, under marital law, determine the value of a business, which is often a couple's biggest asset. For equitable distribution and also for alimony purposes, how much does that business throw off his income? And so a valuation expert will be called in to analyze the company, determine its income, and determine the value of the company. And then the final area or another area that valuation is used is in the context of litigation where there's a dispute over valuation. The valuation expert is called in to determine the value of the company in question. Okay. Thank you for that. Now, does valuation also arise as part of fundraising for private companies? It does. Okay. And does that include private placements? Yes. Okay. Before. I'm sorry. Go ahead. When a company is planning a fundraising, they need to know what price to offer the shares they're going to sell at. So that could be a private placement or it could be an initial public offering. And the people working on the offering will determine a valuation for the company and the shares being offered. Okay. Now, did you review documents relating to the GTV's private placement? I did. Mr. Skirik said, okay. If we could please bring up what is in evidence GXVK 5. Does everybody have it? Okay. Now, Mr. Dragon, are you familiar with this document that's displayed on your screen? I am. Okay. And is this one of the documents you've reviewed in preparation for your testimony? That's correct. Okay. Can you just explain briefly to the jury what this document is? Sure. This is the GTV Media Group Incorporated Private Placement Memorandum dated April 20, 2020. Okay. And is it fair to say that a private placement memorandum is sometimes referred to by the acronym PPM? Yes, that's the case. And sometimes by the acronym CIM, for Confidential Information Memorandum. That could be used as well. Okay. Now, are private placements common transactions? They're very common. Private placements are done very regularly. Okay. And why do companies offer shares of their stock to investors in private placements?
Mr. Ferguson said, objection.
The court said, you may answer.
Investors offer shares of their stock to, or companies offer shares of their stock to investors so that they can raise capital to expand and grow their business. Okay. And is PPM or CIM a general term that's used in the industry? PPM is a commonly used term, and CIM is used as well, although less frequently. Okay. If we could please go to page 2 of this exhibit in evidence, GXVK5. And Mr. Dragon. I'd just like to focus you on the top of this document, the first paragraph. Under the heading Confidentiality and Disclaimer. Do you see that? I do. Okay. And if you could just read that aloud, please. It says, Confidentiality and Disclaimer. This confidential information memorandum is intended for discussion purposes with select parties interested in evaluating an opportunity to invest capital into GTV Media Group Incorporated, the company, or GTV Media. GTV Media is a newly formed company incorporated in April 2020. All descriptions of the business of GTV Media in this document refers to business GTV Media intends to do in the future. There is no guarantee that GTV Media will enter into those identified businesses or that GTV Media will be successful in those businesses. Now, Mr. Dragon, did you consider this language in conducting your valuation analysis of GTV? I did. And what stage of development was GTV at the time? GTV Media was what we would call a startup company. A startup company has a business plan, has looked at the markets it intends to go into, has put together a management team. But it hasn't yet raised money or commenced operations. Okay. Now, is it unusual for a company in the startup phase you just described to seek investment shortly after incorporating?
Mr. Ferguson said, objection.
The court said, overruled. You may answer.
No, it's not unusual at all. In fact, it's typical for companies to go and seek capital because they need the capital to develop their business. Okay. Now, with an early-stage startup company, what ways are there of valuing such a company before it goes into business? In valuing a company like this, you can consider a variety of things: the size of the markets, the potential customers, the products and services that are going to be offered, the potential interest in these products and services, if there's forecasts available, forecasts or projections for the business, and overall, is this an industry that's growing? Is this where other companies have been successful, and if it is, then potentially is this a good business opportunity? Okay. And because a startup company doesn't yet have any historical operating record, does that prevent a business valuation from being performed?
Mr. Ferguson said, object to leading.
The court said, overruled. You may go ahead.
No, it doesn't prevent a business valuation from being done. In fact, there is a whole industry of people called venture capitalists whose job it is to look at business plans and new business opportunities and decide whether they want to invest people's money in them. Okay. Thank you for that. Mr. Skirek said, if we could please, Jorge, just turn to page 6 of this document. And please blow up section 1.3 entitled Goals. Now, Mr. Dragon, could you please read these 4 bullets? Yes. Section 1.3 Goals. To create a unique and the only news-focused social media platform revealing the truth about China. To build an online business trading platform, free of control by the Chinese Communist Party. Focused on the 1.4 billion Chinese people for their personal and business transactions. To be the safest platform to advocate for truth, freedom of speech and religion, justice, human rights, and democracy in China, and to be a bridge between China and the Western world. And allowing for free and open communication, business transactions, and trading, uncensored by the Chinese government. Thank you. Did you consider this language in conducting your valuation analysis? I did. Okay. And how did this impact your valuation analysis?
Mr. Ferguson said, objection, Your Honor. It's outside the scope of the court's ruling.
The court said, I'm going to permit the question.
Could you repeat the question? Yeah, sure, of course. The question is, how did the section 1.3 that you just reviewed impact your valuation analysis? As part of my analysis, I assessed the potential market for a business opportunity in my.
Mr. Ferguson said, objection and move to strike, Your Honor. This is outside the scope. And we may need a sidebar.
The court said, all righty. Step up.
At the sidebar,
Mr. Ferguson said, Your Honor permitted him to testify about the backsolve method. Which is essentially they sold shares at $1 per share, they issued 2 billion shares. A lot of people bought at that price, therefore, its reasonable valuation is $2 billion. He's just talking about the market. Your Honor excluded market approach. This is not the backsolve method. He should not be allowed to offer expert testimony about this. It's way beyond the scope. And it should be stricken.
Mr. Skirek said, Your Honor, I think that analysis is a touch facile. Just because he used the word market doesn't mean that he was using or referring to the market approach to valuation. Which is entirely different from just talking generically about the market that exists for a company's goods or services. As Your Honor knows, the market approach to valuation has to deal with selecting comparator companies and looking at their revenues and looking at their profits and then trying to derive from that information a value based on other data points in the market. That is not at all what he's talking about. Now what he's talking about are qualitative factors that went into his analysis and thinking on the valuation. And that goes into whether or not the backsolve method, when it's applied, is a logical way to check a company's value by using the data points that the court has already approved as being a valid method of assessing valuation. And he's got to be able to testify to these qualitative areas that he took into consideration. The government didn't move on it. There's no order excluding these qualitative factors.
The court said, so I think this is general background information that is relevant to any valuation of a company. Not so specific as to the methods that I've excluded.
Mr. Skirek said, thank you, Your Honor.
Mr. Ferguson said, I would say, Your Honor, it seems like this just doesn't relate to the backsolve method he employed. So we're worried that we don't know how he's going to answer these questions of, what did you think about in valuing the company? We should just get to the backsolve he actually did. Which Your Honor ruled was reliable, and not the things that Your Honor excluded as unreliable. And we did move on it. And the court excluded it.
The court said, do you have any more questions about the market?
Mr. Skirek said, we're just going through he's looking at the PPM, he's looking at the CIM, which is a key document. That's part of his analysis. And I'm just asking him, did you rely on this? What did you take from this? That's all. That's it. I mean, it's...
The court said, what else are you going to ask him?
Mr. Skirek said, there's a handful of other points in this PPM that we're going to go through, and that's really it. And it goes to your point, Your Honor's point. This is background. It's all relevant to the background of valuation.
The court said, how many questions?
Mr. Skirek said, let me just count.
Mr. Ferguson said, in the PPM is the offering of $2 billion shares and $1 a share. And we assumed that was what they were going to go to with the PPM. Not other stuff talking about things that are not the backsolve method. Otherwise we would have raised this objection in the morning before Your Honor.
Mr. Skirek said, well, there are probably 6 or 7 different things I would like to point him to that are all.
The court said, tell me what you want to point him to.
Mr. Skirek said, sure. The section, just to be clear for the record, is labeled goals, right? Goals of the company. That's what we're questioning him about now. The next section is plan. The next section is proposed transaction, which describes the shares that are going to be sold. The next is the summary of investment terms. Risk factors. The fact that the company has no operating history. The fact that the company's management has broad discretion. The fact that the company doesn't expect to gain any dividends. And that's it.
Mr. Ferguson said, Your Honor, he is not an expert on any of those things. He's reading a document as an expert. It's improper expert testimony. They should go to what he actually did as an expert. This is totally improper. You can't call an expert to bolster him reading a document that he has no personal knowledge of as if it were to bolster it. And it violates the court's Daubert orders.
Mr. Skirek said, we completely disagree, Your Honor. This is a foundational document. It is the offering memorandum for the transaction that he is. May I finish, please?
Mr. Ferguson said, yes, of course. I am waiting.
Mr. Skirek said, I didn't interrupt you. It's the foundational document for this transaction that is obviously an enormous issue in this case. And he's got to be allowed to explain what he took into consideration. This document is in evidence, right? He's got to be allowed to say what he took into consideration. And reading factors that go to all of the things that I just read. And it has nothing to do with the market approach or the income approach to valuation, Your Honor. It has absolutely nothing to do with it. We're not asking for him to talk about comparator companies. We're not asking to talk about the projections. The court excluded discussing the Alvarez and Marcel report. We're not going anywhere near it. That is excluded. This is merely background to help inform the jury as to what he relied on in arriving at his opinion. Otherwise there's no rule that says I need to stand an expert up and he just spits out his opinion and it's over. I have to be allowed to provide some context for it.
Mr. Ferguson said, of course he can talk about what goes to that opinion. None of this goes to his actual opinion.
Mr. Skirek said, that's your view, not his. He hasn't even testified to it yet.
Mr. Ferguson said, they qualified this person as an expert, and now they're trying to use that expertise. Clearly in violation of the principles of the Daubert case, to bolster stuff he has no idea about. He's not offering any expert opinion about, he has no personal knowledge of, and he's going to say, yeah, no. That's totally normal, this is.
The court said, you can ask, did you consider the offering memo with respect to? And then just hit the topics without going through the details, not reading from it. Just ask whether he considered those, the plan, etc.
Mr. Skirek said, okay. In that context, Your Honor. May I be permitted to lead so that I can summarize what those topics are?
The court said, no, it's just the general topics.
Mr. Skirek said, okay. All right. Well, I'm happy to give it a shot. I think without being able to ask a somewhat leading question, it's going to be difficult for me to do summary. But I'll do my best.
The court said, well, you can lead to the extent that you can say, did you consider the business plan? That sort of general kind of a question.
Mr. Skirek said, sure. That was my thought, Your Honor, to some extent. Thank you.
The court said, "All right."
Continued on next page. In open court.
The court said, "Go ahead."
Mr. Skirek said, "Thank you, Your Honor."
By Mr. Skirek.
Now, Mr. Dragon, we've just reviewed section 1.3 labeled goals, which is highlighted on everyone's screen. Now is it fair to say that this impacted your valuation analysis?
Mr. Ferguson said, asked and answered.
The court said, "Sustained."
Mr. Skirek said, "I'm not sure we ever got an answer."
The court said, "I'll permit the answer. Go ahead."
Mr. Skirek said, "Thank you, Judge. Yes, I considered this. Can you explain, please?"
Mr. Ferguson said, objection.
The court said, "Sustained."
Mr. Skirek said, "Okay. If we could please go to page 7. And if we can zoom in on the bottom, section 2.1. Titled, Our Plan to Allow the Chinese People to Communicate Freely with the Western World.
By Mr. Skirek.
Do you see that, Mr. Dragon? I do. Did you consider this language in conducting your valuation analysis? I did. Okay. And how did this impact your analysis?
Mr. Ferguson said, objection.
The court said, "Sustained."
Mr. Skirek said, "Your Honor, can we return to sidebar briefly, please?"
Continued on next page. At the sidebar.
The court said, "Mr. Skirek."
Mr. Skirek said, "Yes, thank you. I just want to bring to the court's attention, this is Your Honor's ruling from May 17, 2024. That reads, in relevant part, the court shall not preclude Dragon's qualitative testimony that, broadly, the CCP censorship could create a market that could bolster a company's value. But you precluded him testifying about the related data. And that's precisely the line I'm trying to walk here, Your Honor."
Mr. Ferguson said, and Your Honor, if I may just, the next sentence is about quantitative impact. And he cannot offer any testimony about that, and the question was, did that impact your valuation analysis? Which is going to be a quantitative analysis.
Mr. Skirek said, "I'm sorry. That's completely misconstruing not only what we just all read together, but it misconstrues his testimony. The first sentence says that the court is not going to preclude qualitative testimony. And this is all qualitative, not quantitative. I haven't asked him about any numbers, Your Honor."
The court said, "Can I take a look at that?" So it says, "The court will not preclude Dragon's qualitative testimony that, broadly, CCP censorship could create a market niche that could bolster a company's value. But as Dragon has not offered any data, he shall not be permitted to testify as to any quantitative impact of the censorship on the company's value."
Mr. Skirek said, "We haven't asked him about any numbers, Your Honor."
The court said, "His opinion now is about a number. And so the only logical conclusion that one can draw when you ask what is the impact on his conclusion about the numerical valuation."
Mr. Skirek said, "I mean, respectfully, Your Honor, I have not asked that question."
The court said, "I know that. I know you haven't."
Mr. Skirek said, "I merely asked whether it impacted his valuation analysis, and his thinking as to valuation, right?"
The court said, "So that goes to the number he puts to the value of the company. I'm going to permit you to ask whether he's considered these subject matters, but I'm not permitting you to ask the impact question. We're done."
Continued on next page. In open court.
The court said, "Go ahead."
Mr. Skirek said, "Thank you."
The court said, "Sustained."
Mr. Skirek said, "Now if we could please go to page 9. And if we could focus in on paragraph 3, proposed transaction."
By Mr. Skirek.
Now, Mr. Dragon, do you see this paragraph 3 that is on your screen? I do. Mr. Skirek said, "Okay. And if we could just scroll down to the chart that's on the top of the following page. And Mr. Dragon, did you consider this in conducting your valuation analysis?" I did. Okay. And Mr. Dragon, to your understanding, based on this document, how many shares were being offered for sale in the GTV private placement? The offering was for between 20 million and 200 million shares. And for what percentage of the company did that represent? 10% of the company if it was 200 million shares. And if you could just explain to the jury, in your understanding, who owned the remainder of the shares. both before and after the transaction. The remaining 1.8 billion shares were owned by a company called Soraka Media Group Incorporated. And that was post-private placement, correct? That was both pre and post. Okay. Well, is there a difference between before the transaction and after the transaction? Yes. Before the transaction, the company had what we called a pre-money valuation. The way to think of this is, if I had a company that was worth $5 million and then I raised another $1 million. Pre-money the company would be worth $5 million and post-money it would be worth $5 million plus the $1 million I raised. For a total of $6 million. Mr. Skirek said, okay. Now if we could go to page 16 of this document, please. And focusing in on paragraph 7. Summary of investment terms. Now did you consider this language in conducting your valuation analysis? Yes, I did. Okay. And can you explain what the financing amount would be as part of this transaction? Yes. The amount to be raised could be between $20 million and $200 million. As I understand it. The entire new shares of $200 million were sold, so $200 million was raised. Mr. Skirek said, okay. Now if we could please go to page 18, and just blow up paragraph 9 entitled Risk Factors. Now, Mr. Dragon, did you consider this language under risk factors as part of your valuation analysis? Yes, I considered the risk factors as language here as part of my analysis. Okay. And did you consider the fact that GTV was?
Mr. Ferguson said, objection to leading.
The court said, I did not hear the question.
Did you consider that the investment in GTV was described as highly speculative as part of your analysis?
The court said, so Mr. Skirek, the general subject matters, not the specific language.
Mr. Skirek said, sure, Your Honor. I didn't address any numbers. It was the general subject matter.
The court said, the risk factors. That's the general subject matter.
Mr. Skirek said, if we could go to page 19, please.
By Mr. Skirek.
And this language at the top of page 19, did you consider that as well? I did. Mr. Skirek said, okay. Now if we can go to page 20. And at the top. If we could please blow up that first bolded sentence in the top paragraph. Now what does this paragraph describe?
Mr. Ferguson said, objection, Your Honor.
The court said, all righty. So we're going to stick to the general subject matters, the headings.
Mr. Skirek said, certainly. The general. What is the general subject matter of this paragraph?
The court said, Mr. Skirek, I know you know what I mean.
The general subject matter is that.
Court said, no.
Hold on. I'm going to give you another question.
The court said, he's going to give you a different question.
Is it fair to say this paragraph describes the discretion that the company's management has?
The court said, okay, Mr. Skirek. The heading. Just the general subject matter.
Mr. Skirek said, Your Honor, can we have another sidebar, please?
The court said, so it's separated into sections which I believe are numbered. Those numbered sections. Those are the general headings that I'm referring to, not the subheadings.
Mr. Skirek said, Your Honor, I believe this is a heading.
The court said, I think this is a subheading.
Mr. Skirek said, thank you, Your Honor.
By Mr. Skirek.
This subheading is under risk factors, is that fair?
The court said, well, my point is that you're to stick to the headings and not go into the subheadings.
Mr. Skirek said, and my question was just to confirm that this is under the heading that Your Honor is referring to. Risk factors.
Mr. Ferguson said, we'll stipulate it's underneath the risk factors top heading, Your Honor.
The court said, so this is one of the subheadings, and the government has stipulated to that. Now you can ask about that general overarching numbered heading but not the subheadings.
Mr. Skirek said, okay.
By Mr. Skirek.
The risk factors listed here, is this among the risk factors listed?
Mr. Ferguson said, Your Honor, can we objection?
The court said, all right. So, sir, did you consider the risk factors that were listed?
The witness said, I did, Your Honor.
The court said, okay. Next question.
Mr. Skirek said, if we can go to page 25, please. And if we can blow up, on the bottom of the page, the bolded portion.
Mr. Ferguson said, Your Honor, this is still subheadings.
The court said, would you like me to ask the questions?
Mr. Skirek said, no. Can we have another sidebar, please?
The court said, okay.
Continued on next page. At the sidebar.
The court said, so Mr. Skirek, you're an incredibly smart person. I know that you understand what I'm saying, but you're resisting me, and I want you to stop.
Mr. Skirek said, respectfully, Your Honor, I truly don't understand what the line is that we're drawing between setting.
The court said, let me make it very clear. So you have these numbered sections, and you can ask about what is in that heading that follows the number. None of the text, none of the subheadings. So if it's risk factors, you would say, did you consider the risk factors listed? Period.
Mr. Skirek said, Your Honor, I think I'm trying to understand the difference between just asking about a subheading entitled Risk Factors and the bolded portions which actually list the risk factors. And what the distinction is between being able to elicit testimony about a heading that says risk factors and the substantive risk factors.
The court said, well, because, Mr. Skirek, I know you know the answer. The subheadings are more specific than the general heading. I know that you know this.
Mr. Skirek said, and I'm just trying to understand for my purpose. Frankly, Your Honor. For the balance of the questioning in this case, I want to make sure that I'm adhering to the court's ruling and that I understand. Am I only permitted to ask about headings in certain documents?
The court said, not in certain documents. In this document, you're going through the headings in this document, and their general categories, and following the general categories there's more specific language. It's the specific subheadings and the paragraphs that you're not to go into, just the general categories.
Mr. Skirek said, okay. And I just want to make sure I understand. The reason that I'm not permitted to ask about the specific risk factors is because that is somehow quantitative as opposed to qualitative.
The court said, so you want to ask him about the impact that these representations had on him. And he's here to give us a number. And so necessarily the impact is about drawing this conclusion about the valuation, the number, and so that's where I'm not letting you go.
Mr. Skirek said, okay. And my final question, and I appreciate Your Honor's indulgence, if I'm at some point permitted to ask about the qualitative factors that relate to the portion of Your Honor's ruling that we read before. Am I not?
The court said, we are here. These are the qualitative factors. You can't get into them. You can't have him elaborate on it.
Mr. Skirek said, okay. I understood the court's ruling to permit us to discuss with this witness the qualitative factors that went to the size of the market or the potential market. And that's where I find it, Your Honor, to be clear, that was our understanding of the court's ruling. I believe that's what the text of the ruling said. So I'm trying to figure out how I'm permitted to do that within the confines of what Your Honor just described.
The court said, so now we're moving away from this document to what?
Mr. Skirek said, no. The language in this document is relevant to that, to the market, the size of the market.
The court said, so I'm just going to take you back to where I started. You can ask questions about these general categories without going into the impact, without having him elaborate on the language in the subheadings or in the text.
Mr. Skirek said, okay. Would I be permitted to ask, for example, on the size of the market issue? Whether language in this document, where it says there are 1.4 billion Chinese people who are interested in the content. Can I ask specific questions about that, or am I not permitted to ask specific questions about that?
The court said, no specific questions about that.
Mr. Ferguson said, and Your Honor, he's asked about the risk factor thing. I assume we're going to move on to a different numbered paragraph heading. He asked about it many times.
The court said, okay, we are. I know that we are.
Mr. Skirek said, yes. Just for the record, Your Honor, you know. This seems to me to be inconsistent with our understanding of the court's ruling. We understand the court's ruling now. And we will be guided accordingly.
The court said, okay.
Continued on next page. In open court. By Mr. Skirek.
Okay. Mr. Dragon, the paragraph at the bottom of this page, the second bolded portion, to be clear. Is that something that?
Mr. Ferguson said, objection, Your Honor.
You took into consideration.
The court said, so just stick to the numbered headings.
Mr. Skirik said, understood, Your Honor. Let's move to, we can take this document down. Now, Mr. Dragon, returning to the private placement. What is your understanding of what happened in the GTV private placement? The company sought to raise $200 million by selling 200 million shares at $1 a share. And these would be new shares that did not exist before in GTV media. And they sold the entire allotment of those shares. Okay. And so it was a successful fundraise, fair to say. Yes. Okay. Now, Mr. Dragon, based on your review of the materials that you described before, including the private placement memo that we just reviewed, did you reach a conclusion about the valuation of GTV? I did. Okay. And what valuation method did you apply to reach that conclusion? I applied what's called the backsolve method. That's a method where you look at a transaction in the company's stock and determine if it's a good indicator of value of the entire company. Okay. And is that a valuation, a methodology that looks at the placement of the company's securities? Yes. That's usually, there's some sort of transaction in the company's securities. So a placement of the company's securities would be a transaction in the company's securities. They sold 200 million shares. Okay. And why is the backsolve method a valid valuation methodology? The backsolve method is actually considered one of the best valuation methodologies. The reason it's valid is it is determining the value of the company by looking at the demand for securities in the company. So that if, for example, you sold 10% of the company for 200 million, then that would imply that the value of the total company is 2 billion. Okay. And why is that validation that you just described important? It's very important when you look at a backsolve transaction. You put it to what I would call a three-prong test. The first thing you look at is, was it for a large amount of money? If I only sold one share in the company, whether it was sold for $1 or $20, that wouldn't really tell you much about the value. However, here we sold 200 million shares in the company, and so that's a very significant transaction in terms of number of shares. The second thing that makes the second test is, was this for a significant dollar amount? If we sold a lot of shares but they were for just a fraction of a penny and the overall money raised was only $2 million, that wouldn't tell us much about the value of a $2 billion company. However, here, we sold shares equal to $200 million worth of value, and that is a large amount of money. The third prong of the three-prong test is, was there a lot of people interested in the transaction? At the price the shares were being offered, were lots of people interested in investing in this company? After they went and did their own research and came to a conclusion about whether or not this was a good investment. And we know that there was over 5,000 investors in this company, which is a significant number of investors. Now ultimately, Mr. Dragon, did you arrive at a conclusion about the value of GTV at the end of its private placement? I did. And what was that conclusion? My conclusion was that the equity of GTV, all of its common stock, was worth $2 billion. Mr. Skirik said, thank you, Your Honor. No further questions at this time.
The court said, cross-examination.
Mr. Ferguson said, thank you, Your Honor.
Cross-examination. By Mr. Ferguson.
Good afternoon, Mr. Dragon.
Good afternoon.
I'm one of the prosecutors on the case. I have some questions for you.
Okay.
Now you were testifying as an expert in valuation, right?
That's correct.
And Mr. Skirik had you read a bunch of lines from the PPM. Do you recall that?
I do.
Are you an expert in reading documents?
Mr. Skirik said, objection.
The court said, overruled. You can answer.
I read financial documents daily as part of doing my job, yes.
And you're not offering any expert opinion on reading what a document says, correct?
Mr. Skirik said, objection, Your Honor. It's a really.
The court said, I don't understand the question.
You didn't have any personal involvement in the PPM, correct?
I was not involved in creating the PPM, that's correct.
And you didn't have any personal involvement in the fundraising, correct?
I did not have any involvement in the fundraising either.
Now what you did do was offer an opinion using the backsolve method, correct?
That's correct.
And the backsolve method has a few inputs that are relevant, fair to say?
There's things you look at, yes. I listed them.
And so it's fair to say there's a few inputs that are relevant?
Mr. Skirek said, asked and answered.
The court said, sustained. Go ahead.
One of the inputs is investor demand. You said demand on direct, correct?
That's correct.
And demand depends on the investor views of the value of a company's shares, right?
That's part of what creates demand, yes.
And for GTV, thousands of investors paid $1 a share, right?
That's correct.
And the total amount paid by the investors was significant, right?
It was $200 million in new shares.
And you said that was a, significant amount, is that fair?
That's correct.
And so there was also a large number of investors. The number of investors was significant, fair to say?
The number of investors was significant, over 5,000.
And so your opinion essentially is that valuing GTV shares at $1 per share is a reasonable valuation. Is that fair?
That's correct.
And since there were 2 billion shares, a $2 billion valuation for GTV is also reasonable. Is that fair?
My conclusion was the company was worth $2 billion, correct.
Now this method depends on the investor's assessment of the company, correct?
That's correct.
And it depends on how the investors assess the company's value, correct?
That's correct.
And for this method to be accurate, the investors have to accurately assess the company's value. Correct?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
In a marketplace, you're going to have numerous people look at this. Some people assess it and determine that it is a worthwhile investment. Other people can look at it and determine that it's not. So that overall, you have a supply of shares. And the demand is then met by the people who, after assessing the investment, the industry. How other companies may have done in this industry. Decided that this was a good investment and that the price that the shares was being offered at was a fair price.
I'm talking about the people that actually bought the shares, okay? Do you understand that?
Yes, I understand that.
Okay. So the people that actually bought the shares. The valuation by them is the basis for your opinion, fair to say?
Mr. Skirek said, objection. Form.
The court said, overruled. You may answer.
My opinion is based on the overall transaction. All the people who bought shares and all the people who looked at it. And that is how you come to the conclusion that 10% of the company was worth $200 million, so therefore 100% of the company was worth $2 billion.
But I just want to be clear. Do you agree with me that part of the basis for your opinion is the investors who actually bought the shares at $1?
Yes, that's part of the basis of my opinion.
And if those investors had a misconception about the value of the shares, your method would incorporate that misconception, correct?
Mr. Skirek said, objection. Objection.
The court said, overruled. You may answer.
If those investors had a misconception about the value of GTV's shares, your method would incorporate that misconception, fair to say?
Mr. Skirek said, objection. Asked and answered.
The court said, overruled. You may answer.
Okay. Well. The way that supply and demand works in the market is each investor comes to their own conclusion as to what the opinion was. And those who came to the conclusion that this was a good investment at this price bought the shares.
Mr. Ferguson said, Your Honor, we move to strike as non-responsive, and I can ask the question again.
The court said, sustained. The answer is stricken. If you'll read the question back, sir. If you'll listen to the question carefully and only answer what's being asked.
The witness said, okay. Record read.
If there was a misconception, that's basically assuming that markets don't work. But if there was a misconception on the value, that would be incorporated into their decision to buy the shares.
So is that a yes?
Mr. Skirek said, objection. Asked and answered.
Mr. Ferguson said, I'm just trying to get an answer to the question.
Mr. Skirik said, he answered.
The court said, if you'll just read back the question one more time, please.
Record read.
Mr. Skirik said, I believe he answered it. It's the previous set of questions.
The court said, no, that's the reason that I asked for it to be read back, because I did not hear an answer to the question. Would you mind reading back the question one more time, please?
Record read.
If that was how they made their decision to purchase on a misconception, that would be incorporated into their decision to purchase and my methodology.
Now, Mr. Dragon, you testified that you considered the risk factors in the PPM. Do you recall that?
Yes.
And you agree with me that risks are an important thing to consider when valuing a company, right?
That's correct.
Risk is an important thing to consider when making an investment, right?
That's correct.
That's because risk is about the likelihood your investment will lose money, right?
That is a component of risk, yes.
And when risk is lower, when the likelihood of losing money is lower, the investment appears better. Fair to say?
Mr. Skirik said, objection.
The court said, overruled. You may answer.
Lower risk investments generally are preferred, all other things being equal.
And so when investors are guaranteed there is no risk, the investment that had no risk would appear better, fair to say?
Mr. Skirik said, objection.
The court said, it's a compound question.
Excuse me. Are you asking me whether this investment had no risk?
I'll rephrase.
The court said, go ahead.
If investors are guaranteed there is no risk, that means there's no likelihood of losing money. Fair to say?
That's fair to say, hypothetically, yes.
And if there's no likelihood of losing money on an investment, the value of the investment would be higher, fair to say?
Mr. Skirik said, objection.
The court said, overruled. You may answer.
Yes.
Now if the GTV investors relied on a guarantee there was no risk, the apparent value of the investment is not accurate, in those investors' view.
Mr. Skirik said, objection, form. The word reliance.
The court said, sustained.
Now you agree with me that the likelihood of making money is also an important representation, right?
I'm not sure what you mean by the term important representation.
Well, let me rephrase. If you're assessing the value of investment, it would be significant to know what the potential upside of that investment might be, fair to say?
When you assess any investment, you don't know what the upside is. You can only estimate what the upside is.
Right. And so if someone guaranteed there could only be upside, is that an accurate representation? In your view?
Mr. Skirik said, objection.
The court said, sustained.
Now, Mr. Dragon, the backsolve method you use to value GTV depends on GTV's investors, right?
Mr. Skirik said, objection. Asked and answered.
The court said, overruled. You may answer.
It involves, as I said, on a number of factors. And that's why I applied what I call the three-prong test.
And the method you used, it doesn't factor in at all whether GTV's investors were lied to, correct?
Mr. Skirik said, objection.
The court said, you may answer.
The methodology I used was looking at the legal documents that were provided for the memorandum and the actual purchases by the people who, after making their own risk assessment, were willing to pay the price for the shares.
Continued on next page.
Mr. Ferguson said, move to strike I guess and I'll ask the question again.
The court said, if you'll read back the question, please.
The record was read.
There was no indication on the memorandum that there was any lies. So I did not factor in that the investors were lied to because I don't know whether that's the case or not.
And so that's a yes, you didn't factor that in?
Mr. Skirik said, asked and answered.
The court said, sustained. Go ahead.
You said there's no indication on the PPM that investors were lied to, right?
Mr. Skirik said, asked and answered.
Mr. Ferguson said, I'm trying to get to the next question. Well, you know what, Your Honor. Let's go on. Now, Ms. Loftus. Can we pull up Government Exhibit Z9 at page 6? Mr. Dragon, your opinion is that $2 billion was a reasonable valuation. Right?
Mr. Skirek said, asked and answered.
Mr. Ferguson said, I'm just trying to get to the question, Your Honor.
The court said, go ahead. You can finish your question.
I want to focus you on the exhibit in front of you. Do you see in the top left the date is June 2nd, 2020?
I do.
And do you see that you know that June 2nd, 2020 is the date that the private placement for GTV closed, right?
That's correct.
And the person pictured in this photograph, that's Miles Gua, right?
Yes.
And he's holding up a share certificate in this photo, you see that?
Yes.
All right. I'll ask you to please read the first paragraph listed there.
We had an initial valuation of $200 million for GTV and the private placement required a minimum investment of $20 million. The private placement exceeded the highest expectation and raised $350 million. This is up to now. This figure is about $360 million. Let's say $350 million. $350 million does not include the $117 million from VOG. If $117 million plus $350 million is more than $480 million, which is almost $500 million, almost $500 million. But the figure we have now is $350 million received, which is just for the contracts with GTV. This turned out to be a conservative estimate and 17 times the valuation.
If we can scroll down, Ms. Loftus, and can you read the next paragraph, the one in the middle there?
Given the tremendous demand for GTV shares and the good capital of GTV going forward, my lawyers and financial experts mutually agree that a $2 billion valuation is probably too low and that the actual value of the company is probably closer to $10 billion given the tremendous demand for GTV shares.
Mr. Dragon, just to start. This reference to my lawyers and financial experts who according to Mr. Gua mutually agree that $2 billion valuation is probably too low. You weren't one of those experts, correct?
I was not.
You didn't value GTV in 2020, right? At the time of this, you didn't value GTV?
Mr. Skirek said, objection, asked and answered.
The court said, you may answer.
I was not involved in valuing GTV in 2020. My involvement is in 2024.
You only valued GTV in connection with this case, right?
That's correct.
And you're not offering any opinion that a $10 billion valuation was reasonable, correct?
I'm not offering that opinion.
Were you even asked to try to justify a $10 billion valuation?
Mr. Skirek said, objection.
The court said, you may answer.
As part of looking at the company, I was not asked. But I looked at the company from a lot of different perspectives.
Mr. Ferguson said, Your Honor, objection.
Mr. Skirek said, he asked, Your Honor.
The court said, that last sentence is stricken. Go ahead.
So you're not offering any opinion that $10 billion is a reasonable valuation, correct?
That's correct.
Let's go to GXZ9 at page 76, please. And do you see the date in the top left is March 30th, 2021?
Yes, I do.
And the person pictured here is Miles Gua again, right?
I believe so.
Now let's scroll down to the next page, Ms. Loftus, and let's focus on the bottom paragraph. If we could blow that up. Could you read that bottom paragraph, please, Mr. Dragon?
For GTV, how many funds tell GTV now that with the assessment the worth of GTV is now probably $60 billion? $60 billion. In other words, for the shares you have bought in the past, for example, 1 million shares. How many shares shall we give you now? It's multiplied by 30 times, that is, 18 million shares.
Sir, you're not offering any opinion that a $60 billion valuation of GTV was reasonable, correct?
I'm not offering any opinion on that.
If we could go to GXZ9 at 115. Do you see the date there is August 11th, 2021?
I do.
And the person in the split screen on the left, that's Miles Gua, correct?
I believe so.
Now can you read focusing on the bottom paragraph? Could you read the last two sentences in that paragraph?
Rolex is worth $7.8 billion, which is about $8 billion rounding up, right? It's only worth $8 billion. Which is only 1/5 or 1/6 of our GTV in terms of market value.
If $8 billion is 1/6 of GTV's market value, that would mean GTV's market value is $48 billion, correct?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
If you accept the premise, that would be $48 billion.
That's exactly right.
Mr. Skirek said, objection to the testifying.
Mr. Ferguson said, can I ask the question?
The court said, I did not hear the objection.
Mr. Skirek said, object to counsel testifying.
The court said, don't testify. Go ahead.
You're not offering an opinion that GTV's value was $48 billion, correct?
Mr. Skirek said, asked and answered.
The court said, overruled. You may answer.
I am not offering the opinion.
Ms. Loftus, if we could please pull up GXZ 212V. You can start playing at about 1:39 inches.
Media played.
Sir, you're not offering any opinion that G Fashion is valued at $100 billion?
Mr. Skirek said, objection, Your Honor. Well beyond the scope.
The court said, you may answer.
Well, first of all, I was asked to value the company as of April 2020. Both in this case and in the two previous cases you mentioned. You asked for valuations totally significantly after the valuation date I was asked to determine value. So in that sense, these are questions I haven't even considered. So companies' values can change over time. I can't tell you what the value of the company would be after the valuation date because I was only engaged to value the company as of April 20th. 200.
Ms. Loftus, let's go to GXZ9 at 134, please. The date in the top left here is November 16th, 2021, do you see that?
I do.
And there's a person in the image person in the middle that's Milesqua, right?
I believe so.
Ms. Loftus, can we please play GXZ 432V?
Media played.
Can we go back to Government Exhibit Z9 at 134? Can you scroll down a little bit? Now, Mr. Dragon. You're not offering any opinion that the Himalaya exchange was worth $2 trillion, correct?
Mr. Skirek said, objection, beyond the scope.
The court said, you may answer, sir.
The Himalaya exchange was not part of the scope of my valuation, so I'm offering no opinion.
And you're not offering any opinion that 5% of the Himalaya exchange was worth $100 billion. Correct?
Mr. Skirek said, objection. I was engaged to value the company at the time of the offering memorandum. This is over a year later. This is not something I would look at because it was out of the scope that I was engaged to value the company. I was engaged to value at the time of the offering memorandum in 2020.
It's fair to say you weren't asked to value the Himalaya exchange at $2 trillion, sir?
Mr. Skirek said, objection, asked and answered.
The court said, sustained.
Mr. Ferguson said, may I have a moment, Your Honor? Sir, you testified how you valued GTV around April 2020. Are you aware that Milesqua continued selling what he said were GTV shares well after that?
Mr. Skirek said, objection.
The court said, overruled. You may answer.
Are you asking me whether Milesqua sold his personal shares?
No, GTV shares well after April 2020.
Mr. Skirek said, objection.
The court said, you may answer.
I'm not aware of any sales of new GTV shares after the closing of the private placement memorandum.
Mr. Ferguson said, just one moment, Your Honor.
Pause.
Mr. Ferguson said, no further questions.
The court said, redirect.
Redirect examination. By Mr. Skirek.
Thank you, Mr. Dragon. You were asked some questions on cross-examination about potential investors' misconceptions. You remember that? I remember questions about that, yes. And you were asked whether if investors had misconceptions whether that would be incorporated into the valuation analysis that you performed. Do you recall that? Yes. Now, was one reason that companies selling shares issue written documents like a PPM to avoid misconceptions?
Mr. Ferguson said, objection to leading and improper.
The court said, sustained as to leading. Go ahead.
What is one reason that companies selling shares issue written documents to potential investors?
Mr. Ferguson said, objection. He's not an expert on that.
The court said, sustained.
Mr. Skirek said, he's a valuation expert, Your Honor.
The court said, sustained. Go ahead. Move on.
Now, with respect to potential investor misconceptions. Does the backsolve method assume that every investor has perfect information?
Mr. Ferguson said, objection to leading.
The court said, you may answer that question.
No, it doesn't. Can you explain that, please? Sure. Every single investor is going to read the memorandum and they're going to go and do their own research on, what the prospect for this company might be. And everyone comes to a different conclusion, so there's no way of, that some individual could maybe draw an incorrect conclusion of preventing that. And that's the same for any stock offering.
Mr. Ferguson said, Your Honor, we move to strike as non-responsive and total speculation. He has no personal knowledge of any of that, and it violates the court's order.
The court said, he's not an expert on investor behavior as far as whether they read or not read the prospectus. Move on. The answer is stricken.
Mr. Skirek said, Your Honor, the question is with respect to the methodology, the backsolve method. How does that account for the possibility that investors may have varying levels of information or judgments?
Mr. Ferguson said, asked and answered.
The court said, you may answer that question. Go ahead.
Thank you. The way it accounts for it is a large number of people look at it.
The court said, so you're not to give an opinion though about what individual investors may be thinking or may have read.
The witness said, I'm just talking how markets work, Your Honor.
The court said, go ahead.
The way markets work is an opportunity, whether it's stock or selling a hamburger. Something is put up for sale and people look at it and decide whether it's a good opportunity or not. And the ones who do buy it decide it's worth their money. In this case, there was a very large number of people who looked at it, and over 5,000 people after doing their research decided this was a good investment. Now, Mr. Dragon, you were also asked some questions on cross about the risk factors. Do you recall that? I do. And you were asked about a guarantee. Do you recall that? I do. Now, in conducting valuation analyses, do you take guarantees into account? I might. Can you explain that, please? Yes. If there was a guarantee that was backed by legal documentation and that after discussing with an expert in, say, guarantees, a lawyer or something who understands this area, if they said that the guarantee was legally valid, then I would consider that in my valuation.
Mr. Ferguson said, Your Honor. Objection and move to strike to the hearsay of what may be some legal conclusion on a speculative nature.
Mr. Skirek said, there's no hearsay, Your Honor. This is about how valuation analysis works.
The court said, I'm going to permit the answer. Let's continue.
Thank you, Judge. And so if a valuation analysis the guarantee were one that was not valid and legally binding, would that affect your analysis?
Mr. Ferguson said, Your Honor, objection.
The court said, you may answer.
Mr. Ferguson said, he cannot testify about legal conclusions.
The court said, you may answer as to what would affect your analysis.
If I felt the guarantee was legally binding and had the ability to be backed up with sufficient resources, then I would consider it in my valuation. However, if it's just someone talking and there's no legally binding document, I would not consider it.
Mr. Ferguson said, Your Honor, I think we need to approach. I apologize.
The court said, all right.
Continued on next page. At the sidebar.
The court said, Mr. Ferguson, you opened the door to guarantee.
Mr. Ferguson said, I didn't open the door to him opining on whether oral guarantees are legally binding versus written guarantees are legally binding. He is not an expert in that. He has no expertise to offer about it. Second, the point of these questions, Your Honor, like we've objected to many times throughout the trial, is to suggest that the victims were gullible or negligent and they listened to this guy make some crazy guarantee, and isn't it really on them?
The court said, I think that you opened the door wide enough to permit these questions, and I think he's about to stop, so we're going to move on.
Continued on next page. In open court.
The court said, the answer stands.
In addition to the guarantees, you were also asked some questions about a document that is in evidence called GXE9, the chart. Do you recall that? I probably would if you showed me the document. I don't know the code number. If we could please pull that up for the witness and everyone for that matter. And if we can go to the entry from June 2, 2020, which I think is on page 6. Do you recall this now, Mr. Dragon? I do. And Mr. Ferguson asked you some questions about this. You recall that? He did, yes. And you recall that this is the date on which the GTV private placement closed, is that right? That's correct. There's a reference here to a potential, withdrawn. There's a reference here that you read that the private placement exceeded the highest expectation and raised $350 million. Do you see that? Yes, I do. Now do you have an understanding as to what is being referred to here? My understanding is that the $350 million includes the $200 million of new GTV shares that were issued by GTV and includes shares that were owned by Soraka that were sold because there was a very large investor interest in this offering. And so it's fair to say that GTV sold more than $200 million worth of shares. GTV itself sold $200 million. And the remainder came from where to your understanding? Soraka sold some of the GTV shares it already had. Now, did
Mr. Ferguson said, Your Honor, what is the basis of this? I'm sorry. I think we may need a sidebar. Your Honor. Apologies. We object on personal knowledge.
Mr. Skirik said, I'm not sure how that's an objection to the question, Your Honor.
The court said, if he has personal knowledge you may answer.
Now, there's also reference here, if we scroll up a bit in this chart to the middle paragraph beginning. Given the tremendous demand. Do you see that? I do. You read this on cross-examination with Mr. Ferguson as well, right? Yes. And it reads, given the tremendous demand for GTV shares and the good capital position of GTV going forward. My lawyers and financial experts mutually agreed that a $2 billion valuation is probably too low. Do you see that? I do. And then you were asked some questions by Mr. Ferguson whether a higher valuation was something that you evaluated. Do you recall that? I do recall that. Now, did you have access to the information that Mr. Gua did at this time in June of 2020?
Mr. Ferguson said, objection, how could he possibly know that?
Mr. Skirik said, I think he would know.
The court said, he doesn't know what Mr. Gua knows, so he can't answer that question.
Mr. Skirik said, Your Honor. Can he answer the question whether he had access to the lawyers and financial expert who were referred to here?
Mr. Ferguson said, objection.
The court said, sustained.
Did you have access to any information about the GTV fundraise apart from what you received in connection with your testimony here today? No. So you didn't have access to, or you don't know whether Mr. Gua had access to a broader set of information than you did? Right.
Mr. Ferguson said, calls for speculation.
Mr. Skirik said, you don't know. The question is you don't know.
The court said, he can answer whether he knows or doesn't know. You can answer.
I don't know what Mr. Gua had access to. Right. Now, in order to determine in your expert opinion whether a higher valuation was justified at this point in time, you would need access to a broader set of facts.
Mr. Ferguson said, objection to leading.
The court said you can answer. Go ahead.
I considered.
The court said, the question is not what you considered.
I would have to have access to additional information if I were to try and determine whether a higher valuation was justified. Now, at this time your understanding, this time being June 2nd of 2020. Your understanding is that the private placement is closed, correct? That's correct. So what was said here by Mr. Gua available to GTV investors in the private placement? No. Now, you were also asked several questions by Mr. Ferguson about statements that were made by Mr. Gua later in time concerning the valuation of GTV. Do you recall that? I do recall that. And you were asked some particular questions about a statement about a $60 billion valuation that was made in 2021. Is that right? I was asked about that, yes. Did you look at information from that point in time to be able to assess whether that valuation estimate was fair at the time it was stated? No, I didn't. My assignment was to value the company as of the time of the private placement in April 20, 2020. You were also asked a similar set of questions by Mr. Ferguson about a $48 billion valuation that was implied from something Mr. Gua said in 2021. Do you recall that? I do. Same question, did you have access to any information about the valuation of GTV at that point in time? No, I didn't, and that was not in the scope of my assignment. You were also asked some questions by Mr. Ferguson about G Fashion. Do you recall that? I do. Do you know what G Fashion is? Not intimately, no. Fair enough. And you weren't asked to value G Fashion, right? That's correct, I was not. Same question with respect to the Himalaya Exchange. You weren't asked to value Himalaya Exchange. I was not asked to value the Himalaya Exchange either. Now, does any of what we just talked about, the 2021 statements concerning valuation about GTV, affect your opinion as to the value of GTV at the time of the close of the private placement? No, it doesn't. Valuation experts consider what is known and knowable at the time of the valuation, which was April 20, 2020. And the window of the private placement memorandum offering. Mr. Skirek said, "Thank you. No further questions."
The court said recross.
Recross examination. By Mr. Ferguson.
Sir, you didn't work at GTV, correct?
No, I didn't.
You didn't work at Soraka, correct?
No.
In 2020, you didn't work for Milesqua?
That's correct.
In 2020, you didn't do any valuation of GTV, correct?
I did not value the company in 2020, if that's the question you're asking.
Thank you, Mr. Dragon. Now, Mr. Skirek asked you questions about other valuations of higher numbers on redirect. You remember those?
I do.
And you testified you didn't have any information about those later valuations, isn't that right?
Mr. Skirek said, "Objection, misstates testimony." What I testified to.
The court said, overruled.
What I testified. My assignment was to value the company during the period of the private placement memorandum. And that valuation was known and knowable at the time of the private placement offering.
The materials you reviewed were provided you by the defense lawyers here, correct?
That's correct.
You don't have any personal knowledge that factored into your valuation related to GTV, correct?
Mr. Skirek said, "Objection, asked and answered."
The court said you may answer.
It depends what you define as personal knowledge.
Well, you relied on the material they gave you, that's fair to say, right?
I relied on the materials I was given and also on research I did independently.
Sir, they didn't give you materials to justify a $100 billion valuation of G Fashion, fair to say?
Mr. Skirek said, asked and answered 3 times.
The court said you may answer.
I'm not sure what the question is. Could you restate that, please?
They didn't give you. The defense lawyers did not give you materials to conduct a valuation of G Fashion for $100 billion, correct?
Mr. Skirek said, same objection.
The court said, overruled.
Valuation experts by our professional standards are not allowed to be given a value by legal counsel. We come to our own independent conclusions.
They didn't give you any documents related to that, is that fair?
Mr. Skirek said, objection.
The court said you may answer.
Mr. Skirek said, related to what?
To G Fashion and the valuation of it.
I was not hired to value G Fashion. I was hired to determine the value of GTV at the time of the private placement memorandum.
Did the defense lawyers ask you to value G Fashion in 2021?
No.
Did the defense lawyers ask you to value GTV in 2021?
Mr. Skirek said, objection, this has been asked and answered repeatedly.
The court said, sustained.
Sir, you don't know what the investors who have testified in this trial have said, correct?
Mr. Skirik said, objection.
The court said, you may answer.
I have not been present at this trial until today. So I have no idea what has been said beforehand.
Mr. Ferguson said, no further questions.
The court said, all righty.
Mr. Skirik said, no questions, Your Honor.
The court said, thank you. You may step out, and the defense may call its next witness.
Witness excused.